I'm Vinnie Politan. The subject of my investigation is the death of Boston police officer John O'Keefe. His girlfriend Karen Reed is accused of his murder, but when she shows up at the courthouse, the crowd of spectators cheers for her because they believe she's been framed. Here's the story. It was the biggest, most divisive trial of 2024. Karen Reed accused of murdering her boyfriend, Boston police officer John O'Keefe. Prosecutors said she ran him over in a jealous, alcohol-fueled rage and charged her with murder. But the defense painted a different picture, a police cover-up spearheaded by the lead investigator, Trooper Michael Proctor, who framed Karen Reed for murder. The trial drew a lot of attention, and the public's passion for the case has continued to grow. This manifested itself on social media and created a very intense situation at the courthouse. Karen Reed supporters were dressed in pink, while those who supported the police wore blue. That same divide seemingly existed in the jury room, as the case ended with a deadlocked jury in the 3-count indictment. Now Karen Reed will be tried again, and the battle is continuing in the courtroom as prosecutors try to limit the evidence the defense can present, including crucial expert testimony. This trial took on a life of its own. So different than cases that I've covered for years and years and years here at Court TV. And there was one piece of evidence that early on really, I think, triggered the movement, which was the Free Karen Reed movement. It was an alleged Google search that was done about how long it takes for someone to die in the cold. And from the defense perspective, that search was done at 2:27 in the morning, which would have been done by someone who was at the house where John O'Keefe was found dead on the front lawn of. But it was 2:27, someone who was at the party that night. Such an important piece of evidence in this case. So I want you to take a listen to Jennifer McCabe, the one who made this search. And what's really in question is, what time did she make that search on her phone? Take a listen.
Did you, in fact, use a phrase to Google search how long it takes for someone to die of extreme temperatures?
I did in the morning at the request of your client.
Okay. And what phrase did you use?
I'm not sure.
Really? Are you telling me you don't remember what Google search you put in?
Karen was screaming, my hands were shaking, and she was saying, Google hypothermia, how long does it take to die in the cold?
And what phrase did you put in your phone? I'm just asking you to say it.
Why don't you show me it?
You see this first search that says how long to die in cold?
I do.
What's that time?
You've got the, it's right over at 2:27.
AM or PM?
AM.
Ms. McCabe, you made that search at 2:27 AM because you knew that John O'Keefe was outside in your sister's lawn dying in the cold, didn't you?
Absolutely not. I did not make that search at that time, no.
You realized the next morning, after John was discovered, after 6 AM, that you had an incriminating search on your phone, didn't you?
Absolutely not.
To cover your tracks, you searched it again in order to overwrite the original search at 2:27, correct?
Again, absolutely not.
Now, in our coverage of it here, the first time I ever spoke with Alan Jackson, Karen Reed's attorney, and I was interviewing him about this, he was convinced, and this was such an important piece of evidence for him. And it was a huge piece of evidence for the Free Karen Reed movement. That's what he was saying. Then we had a whole trial, and other things came up. Trooper Proctor, other issues were raised about the way the investigation went, etc. So, looking at it now, my first question in our investigation is, How important is the Google search for the defense as they get ready for the retrial? Going into the first trial, we're like, this is it, right? This is it. If that search is at 227, there's no way Karen Read is guilty. No way. But is that the only road to not guilty? Is this the piece of evidence? Is this the make it or break it? Joining me, Massachusetts criminal defense attorney Joseph Krowski Jr. and trial attorney who served as special counsel to Johnny Depp in his defamation case, Wayne Dennison, is with us. All right, Joseph, how important is it as we get ready for the second Karen Read trial, having seen all the evidence, the cross-examination, defense theories, everything else, for the defense, how big is this Google search for them?
Well, I don't think it can be overstated. If they can establish it, and that's a significant if, and you could say that about most pieces of evidence. And again, they don't have any burden of persuasion, but they do have to essentially have a jury believe the search took place at 2:27 a.m. If a jury were to believe that, and again, it's a big if, then that gets them, 9/10 of the way to reasonable doubt. Unlike some of the other aspects of the conspiracy theory that are, quite frankly, in my opinion, implausible, if a jury were to conclude that that search took place at 2:27 a.m. by Jennifer McCabe, there would be no other explanation than she had first-hand knowledge O'Keefe was out on the front lawn. And again, that's not a concession by me that I believe the search took place at that time, but it's critically important to the defense. It's not the only pathway home. Again, they have the presumption of innocence, but I think we can all agree that that really is the cornerstone, the anchor of the conspiracy theory. It's the thing that generated the most pretrial publicity. I think most people, when they first heard it, were aghast at it until they really started to get into the forensics of it. But yeah, it can't be overstated. It's a huge piece of evidence for the defense.
And the crowds that were showing up, the signs that were being held, a lot of it had to do with this how's long to die in the cold. Wayne Dennison, is this a make it or break it issue, or is there another potential road to reasonable doubt in this case for Karen Read?
It's an important issue, but it's not a make it or break it issue. There is a road to reasonable doubt that doesn't require it. But the importance of this is clear cut, or the prosecution wouldn't be trying to exclude it. It is an important piece of evidence. It's a piece of evidence that doesn't require a grand conspiracy among law enforcement to get to this, to get to the result of an acquittal. And it's a very important piece of evidence. But as Joseph said, she has a presumption of innocence, and there are multiple roads to acquittal.
I want to take a listen to Ian Whiffen, who was the expert witness for the Commonwealth on the issue of when this search was. And then you'll hear from Richard Green, who is the defense expert. Let's watch.
In conclusion, I determined that the tab that was used was focused at 227.40. So the tab was opened at that time, at which point it was being used to show Ozone Basketball and Hockomock Sports websites. The 6:23 timestamp is when the search was first conducted. Never loaded the page, otherwise there'd be a record in the history database. And while that page was still loading, a secondary search was conducted for Hoss Long to Die in the Cold.
Do you have an opinion as to the timing of that first search for Hoss Long to Die in Cold?
Yes, I do.
What is that opinion?
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
So it was one of those battle of the experts, Joseph, but how do you see this? Is it about the experts? Is it about Jennifer McCabe's credibility? Which is more defining in trying to figure out if that search is done at 2:27 or at 6:23 in the morning?
Well, the experts' testimony is critical in this case. The advantage the Commonwealth has in this regard, though, if you recall, they also have Jessica Hyde as an expert who gave testimony regarding the extraction of the cell phone. Unlike Richard Green, and look, no disrespect to him, he's certainly an educated man, Ian Whiffen actually works for Cellbrite. He's not a typical paid-for expert. He's a senior analyst at the company that designed, developed, and patented the extraction software. So he brings a certain imprimatur with him from the company, so much so that the company, when they realized that the software was open to a misinterpretation of a timestamp, they changed the software. That could have huge consequences for the company going forward. I don't think they did that lightly. I think they did that because they believe that 2:27 time really reflected the time that the tab was opened, not that the search took place. And if we have a battle of experts and all things end up being equal, then it's a wash and we go on to the other evidence. But yes, certainly expert testimony on that issue is going to be critical. We don't know that the defense is absolutely going to call Richard Green. They have no burden of proof, no burden of persuasion. But when, as a defense attorney, you make that calculated decision to put someone up there, I think you own it a little bit, and the jury expects that you're going to be able to prove it, or at least establish it to some modicum of a burden of persuasion.
So, Wayne, this is going to be, again, a classic battle of the experts. What I've seen through the years and a lot of the other trials I've covered, one expert says this, one expert says that, and sometimes jurors will look at the other evidence. Well, in this case, the other evidence would be Jen McCabe, her testimony, people that were there at 6:23 in the morning. What are your thoughts about what's more significant and how the jury gets to the truth of when the Google search was done?
Well, they're going to take an independent evaluation of every single expert and every single witness. And whether Jen McCabe comes off as a credible witness is going to be just as important as to whether you believe this expert over another expert. Ultimately, a battle of the experts comes down to who is more believable, who is more relatable. But we have lots and lots of other witnesses, but Jen McCabe is going to be central to whether this story holds together.
All right, Joseph Krowski Jr., Wayne Dennison staying with us. Coming up next, we're going to zoom in now on the defense expert. How important is Richard Green's testimony?
I'm going to start with the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. It's rather a difference of opinions that need to be resolved by the jury. So I'm denying your motion. I'm not going to exclude the evidence.
It was the biggest story in the world.
People saw the facts differently.
Somebody manufactured evidence in this case.
This was kind of a crazy spectacle.
This case is a circus.
He was an icon. They are in for the fight of their lives. Everybody thinks you're guilty.
Trial and Error. Why did O.J. win? A Court TV original series. Premieres February 16th. Only on Court TV.
At the end of the day, clearing away all the confusion of the Commonwealth's experts, we're left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted.
So Alan Jackson, the attorney for Karen Reed, talking about his expert. That expert's name is Richard Green, and he testified in the first trial. It was a big moment during the course of the case. There were a lot of big moments in that trial. I want to take a listen to his testimony, and this is an expert who the prosecution tried to keep from being able to testify in the second trial. Take a listen.
Do you have an opinion as to the timing of that first search for Hoslam to die in cold?
Yes, I do.
What is that opinion?
that would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
And what is the basis for your opinion?
Again, by how this particular phone operates with that exact operating system and comparing it to other data on that phone and the way it presented it out, is all consistent with that search happening at or before that time.
And what opinions or conclusions did you reach regarding how, if any, how the 2:27 a.m. search was deleted?
Well, we know that that's in a deleted state. And importantly on that phone is I keep using the proverbial we, I found a lot of other that would have been used or deleted artifacts between midnight and the early mornings on January 29, 2022.
Okay, so this is the witness who we presume is going to get onto the witness stand again in the retrial because the prosecution was not successful in preventing him from being allowed to testify. And that brings us to the next question in our investigation. How important is Richard Green's testimony? Big witness. Still with me, Joseph Krowski Jr. and Wayne Dennison. Wayne, I'll begin with you. Because there's going to be the other side. The other side has the guy who works for the company, Cellbrite. So how important will this testimony be, and what does he have to do to overcome the expert who works for the actual software company?
Well, it's going to be important testimony, and ultimately all he has to be is more credible than the other guy. The technical aspects of this is likely beyond the ken of the jury, or beyond what the jury is ultimately going to understand in terms of how this artifact works or how that artifact works. And it's going to be, quite frankly, the sense of which guy appears to know what he's talking about and which guy is telling the truth. He's an extraordinarily important witness because he is a path to an acquittal.
Okay, Joseph Krowski Jr., and we always bring in attorneys who know the law in the state and the way things work inside these courthouses. Both of our guests tonight do. Joseph, I have a particular question for you, because on social media, there have been some postings about someone whose name is Richard Green down in Florida got arrested. Misdemeanor charges back in like 2014, 2016. I also saw a dismissal, it looked like, that was signed after a successful pretrial intervention like in 2018. Does any of that potentially could be used, if it's the same Richard Green, at trial by the prosecution to cross-examine him, to attack his credibility?
No, I don't think so. If it is the same Richard Green, it sounds like he had a memorable night at McNasty's down in Florida. In Massachusetts, to impeach the credibility of a witness, when we're talking about a civilian or an expert, a non-law enforcement witness, it's governed by statute, and it requires a conviction, and there's certain time limitations on it. A dismissal is typically not admissible to use for impeachment. For the sake of argument, even if it were, I wouldn't go down that road. I mean, Richard Green, certainly educated, looks like a good, solid, likable human being. So if you're going to come at Richard Green, come at him on his methodology. Come at him on his opinion. Don't attack him personally. I don't think that would engender any goodwill with the jury, and might just conversely engender some sympathy for Richard Green. So that is so remote and irrelevant. It's not admissible statutorily, but even if it were, I wouldn't touch it if I was the prosecutor in this case.
So let me ask you, Wayne, what does the defense do second time around in their opening statement? Do they lean into this 227 Google search and our expert will prove it to you? Do you think that is going to be a cornerstone of their case? Do you think they just let it happen and see how it goes? How do you think they're going to approach this particular issue second time around?
I think you're going to lean into it in the opening. How hard you hit it is going to be up to Alan Jackson, but ultimately there is going to be reference to it in the opening. They might even reference to the battle of the experts in the opening, but quite frankly, I can't see them not talking about it in their opening statement.
So let me ask you, Joseph, you know the new prosecutor. How do you think he'll go after Richard Green? And do you think he will be able to undermine his position, his opinion, the way he sees the evidence?
Well, I alluded it in the prior segment, right? The company itself has done a lot of work for the Commonwealth. They've actually changed the software. The interpretations are different, and they're allowing their senior analysts to come and testify. So I think the prosecutor is going to be forceful and methodical. And again, he's got the advantage of having an employee from the company. But certainly it's going to be pretty compelling. This is going to go down as one of the most watched trials ever in the history of this country. I have no doubt about that.
Yeah, and this is rare because it's going to be a retrial. We've had retrials before on court TV, and usually they're anticlimactic. They're not. There's not as much hype for the retrial, not as much interest. This one, it's exponentially higher, and it's really unreal. Big thank you, Joseph Krowski Jr., Wayne Dennison. Always great to have you on the program. I know your time's valuable, and we appreciate it. Up next, has Karen Reed changed her story? I'm Vinnie Politan. We continue our investigation of the death of Boston police officer John O'Keefe. Prosecutors say he was murdered by his girlfriend Karen Reed. Karen Reed says he was killed by other police officers at a party, and the jury in the first trial could not agree. Here's the story. They show up wearing pink, some of them holding signs. They line the streets cheering on a woman named Karen Reed. She is not a celebrity. She's not a war hero. She's a college professor accused of murdering a Boston police officer named John O'Keefe. John and Karen were a couple who were practically living together. On the night of January 28th, going into the early morning hours of the 29th, they were out together, first at C.F. McCarthy's in downtown Canton, Massachusetts, then at the Waterfall Bar, and finally inside Karen's SUV in front of Brian Albert's house, who was hosting an after party with a bunch of the folks who were at the waterfall. The big question is, what happened to John O'Keefe after he stepped out of Karen's car? Did Karen run him over, or was he killed by someone at the party? Well, the jury couldn't figure it out, so a mistrial was declared. And now a new trial has been scheduled, and the passion and intensity of the public and the parties involved has only grown, setting up an epic rematch inside and outside of the courthouse. So Karen Reed didn't testify at the trial, but she has told her story several times to different people and has granted interviews to different members of the media. She spoke with Boston Magazine, and Boston Magazine, the reporter apparently has some notes and things that were not part of the article, not part of the public reporting, and the prosecution wanted to get their hands on those notes. I want you to take a listen to the attorney representing the reporter and the media arguing about why the prosecution should not get the notes.
Well, Your Honor, there's nothing in the interview notes that is reflected in the story except architectural details, that there's a rosary on the bureau or the wall was blue or whatever it might be. And I went through the notes with this question in mind. Can you separate the impressions and integrity of the thoughts of the writer from the statements of the interviewee, and I don't think they're distinguishable. I think they're all melded together in one. And frankly, it's her selection of questions that she asks Ms. Reed that gives an eye hole into what her thoughts are about the case. She shouldn't have to produce that work product. And the Commonwealth hasn't shown that there's any more relevancy to these conversations with Gretchen Voss than there would be with any other conversation that Ms. Reed had with anyone else. There's no reason for the Commonwealth to be going after Gretchen Voss as a report for this, other than the fact that she's a reporter and she's done the investigative work already that presumably the Commonwealth has already done.
So that reporter, Gretchen Voss, didn't want to give up her notes. And different states have different rules about whether they can, whether parties in a case can get that product, that work product, you know, pieces of your work that didn't end up in the article or didn't end up in the story on the news. So take a look at the judge's order here, because the judge actually reversed herself on a motion for reconsideration. The court allows Voss's motion for reconsideration and will not require disclosure of her handwritten notes of the July 7th, 2023 off-the-record interview. Again, prosecutors wanted that because they believed it would be a treasure trove of Karen Reed's statements that would show that her story has changed through time. Which brings us to the next question in our investigation, which is, has Karen Reed's story changed? Again, she didn't testify during the trial, but she has spoken many, many times about what happened that night. Joining me, Karen Reed supporter and creator of the Justice for Officer John O'Keefe and Karen Reed Facebook page, Nick Rocco, and the creator of behind the Yellow College Tales YouTube channel, Kevin Lenahan. Sorry, Kevin. All right, thank you both for being here. Let me start here. Nick, have you heard different stories from Karen Reed? Like at any point in you know, figuring out what happened here, have you seen the story change? Have you heard the story change?
I would say no to that. If anything, like you just said, they're figuring out what happened. So when this first happened, you know, no information was given. And then as time evolves, as we can see just 3 days ago, new video footage is being provided to the defense team, kind of filling gaps into this story. So an interview that maybe was done 2 years ago is going to look a little different than an interview that might be done today or tomorrow, just due to the fact that 3 years after this murder happened, there's new evidence and new video footage coming. So of course, you know, the story as to what happened didn't change. It's just evolving in the sense of they're finally putting the pieces together. And, you know, it's told in a different way, every interview, but it's always the same information. She dropped John off. She ended up going back home. She never reversed. She never said, I hit him. You could take each word she says and try to spin it. Oh, well, she said it this way this time and this way a different time. But it all comes back to the same story, that she dropped John off and she went back home.
Kevin, I want to take a listen to some of the testimony from the original trial, from the first trial, right? And this is one of the firefighters who responded there. And this is what the prosecution's theory is, and these are the alleged words that the Commonwealth believes Karen Reed said. Let's take a listen.
The only response that I was personally given was just, I hit him, oh my God, I hit him. So she was within 2 feet of me, but very loud. Any type of follow-up questioning, did you hit him with your hand? Did you kick him? What happened? She just repeated the phrase over and over again, I hit him, I hit him.
Okay, so that was pretty much how the trial started initially. There were a few witnesses that said that to more or less the same way. And there was cross-examination, obviously. Now I want to take a look at this as well, Kevin, and then get your take so far. The Commonwealth statement of the case. This comes from that document. On January 29th, Troopers Buchanan and Proctor arrived at the residence in Dighton, Mass., the home of the defendant's parents. The defendant agreed to speak with the troopers. The defendant indicated to the troopers that she had met the victim at C.F. McCarthy's bar in Canton at approximately 9 o'clock the evening prior. When she and the victim were leaving the waterfall, she stated they were invited to a house on Fairview Road. The defendant stated that she had dropped the victim at the house on Fairview and went home since she was having stomach issues at the previous bar. The defendant stated that she dropped the victim off, then made a three-point turn in the street and left. She stated that she did not see the victim enter the residence. Okay, Kevin, from your perspective, do you believe, have you seen inconsistencies or a change in a story from Karen Reed?
The story has definitely been evolving, and people, I guess, can decide in the public, and the jury is ultimately going to decide as to what the meaning of that is. Is she changing her story to fit the facts or to fit the theory that she's trying to present? We should remember that John died on a Saturday. Karen was arraigned on the Wednesday. And at that time, her lawyer did not say that her client didn't commit the crime. So she was not saying at that time, I didn't do this. She wasn't, it doesn't sound like she was saying that I saw John go in the house. Now, over time, her story evolved, and she talked about seeing John walk up to the door, walk across the threshold, start to walk into the house. At one point, no, for a while, she was talking about sitting outside as though waiting for John to give her the okay to come back in to join the party. And she said she's texting and calling John repeatedly. But she no longer says that because the records from the first trial showed that's not true. She never texted John at all until I think it was 12:54. And by then she was already at home at John's place. The first phone call comes at 12:33 when she was almost certainly on the road. So the story is consistently evolving depending on what she needs to do. And I guess is what the impact will be on the jury. I think the biggest impact, they'll probably just look and say, she's willing to talk to reporters. Well, why isn't she willing to talk to us? And I know they're not supposed to factor that in, but I think they will.
Well, they're not allowed to. We know that. But
Right.
You're right. Maybe they will. But I trust jurors to follow the judge's instructions.
Yeah.
Okay, I want to play something else. This is body cam video. This is after Karen Reed is indicted in June of 2022. Let's take a listen to her voice.
And you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian McCabe Albert. I mean, we're all in on the same joke, right? My tail light was cracked and John was pulverized.
Okay, now before her first trial, Karen Reed spoke to ABC News' Matt Gutman in an interview that aired on Nightline in August of 2023. Here's what Karen Reed said back then about dropping John off at the Alberts' home.
I pull at the foot of the driveway. It's snowing. John has no coat on. It's windy. So I drop him off. He goes up the driveway and approaches the side door. And as I see him approach the door, I look down at my phone.
Reed says after about 10 minutes of waiting in her car, she became irritated that O'Keefe still hadn't gotten in touch with her. And she drove back to his home where she continued calling him before, she says, she fell asleep around 1:30 in the morning.
Okay, guys, we're getting in a lot of these different pieces of statements, so stay where you are because we're going to continue this discussion after the break.
But it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
A true crime tragedy out of Tennessee.
This case is unlike anything I've ever been involved in.
A 15-month-old Evelyn Boswell goes missing and is later found dead on her family's compound.
Her own teenage mother charged with little Evelyn's murder.
This little girl was let down by everyone in her life who was supposed to protect her.
But it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Karen Reed on the courthouse steps, proclaiming her innocence and saying, we know what really happened here. And that's the defense side of this story, that there's a cover-up. She was framed. And she's spoken many, many times, and we're still investigating the same question. And it's an important one. Has Karen Reed's story changed? Because she's spoken out several different times in different contexts. Still with me, our trial insiders, Nick Rocco and Kevin Lenahan. At some point, Karen Reed also spoke to NBC's Dateline, though it's not clear exactly when the interview took place. The episode aired in October of 2024 after the hung jury.
Karen says they pulled up to the house and she waited in her SUV while John went to check things out. She says she watched him go to the door, put his head inside, then nothing.
I texted him, I called him, and within minutes of him exiting my car, is not answering his phone. Minutes. So
what happens next?
I left.
Okay, Nick, to me, this is very significant. It's the moment that she's in front of the home. And every time she has told the story to different people about what happened that night, does she say she sees John go inside the house, go down the walkway, or just get out of the car? What exactly is the story? Because in a lot of these TV stories, you hear a little bit of Karen, then you hear the reporter. So it's not 100% clear to me. What's your understanding?
I think regardless if she saw him go in the house or up the driveway, he still got out of the vehicle and was heading towards the house to go inside because that's where they were invited to go. And one thing I think a lot of people should understand is whether the story changes 1,000,001 times, the evidence does not point to her doing this. And the federal government also confirms that John was not struck by a vehicle. So even if she blatantly said, yeah, I did it, well, guess what? The Commonwealth still has to prove that she did it, and they don't have the evidence to prove she did it because she didn't do it. Do you really think the FBI and the DOJ are going to take over 2.5 years and still to this day investigating this case and the murder of John O'Keefe? If they had the slightest doubt that Karen Reed did this, they would not be wasting their time. There's just no way, regardless of what is said in an interview. He went up the driveway, he went up to the door, he used the side door, he used the front door. The evidence doesn't point to her doing this. So, I mean, at the end of the day, nothing is technically under oath in these interviews, so she could say whatever she wants, but the Commonwealth doesn't have the evidence to prove she did it. So I don't think it really necessarily matters to what extent she's saying, the side door, the front door, walking up the driveway, peeking his head in. The story's the same. He got out of the car and was heading towards the house.
Now, in November of 2024, the Commonwealth also filed a motion for access to unaired portions of an interview that Karen Reed's parents did with Boston 25 back in August of 2023. In that interview, Karen's dad said she made statements to him about when and how her taillight was cracked.
During your first discussions with Karen, did she believe she may have hit John?
No. No. She felt she struck something. She said, Dad, I think I struck something. I said, what do you mean? Right? This was in the hospital. Right? She says, I remember, all right, backing up and hitting something.
Now, according to Boston 25, in that interview, Karen's dad said what she struck was John O'Keefe's SUV, you're watching the video now, leaving his driveway the next morning. Kevin Lenahan, what are your thoughts about this and how it relates to Karen Reed's story?
Well, let me find some common ground with Nick, and let's focus on the actual evidence. So Karen and John are coming down Cedar Crest Street. They miss the turn onto Fairview. She does a 3-point turn. They take the turn onto Fairview at 12:24 and 18 seconds. So they're just turning onto the street at that time. They pull the 34 is a couple houses up. So we know they pull up in front of the driveway. Now, I don't know how long she sat there, but we know that according to John's GPS, which is very accurate, John's phone had already reached the far edge of the property by 12:24 and 40 seconds. So she couldn't have stopped very long at that driveway. She couldn't have stopped. To get to the far edge of the property, that's about another 80 feet. Where from that angle, she couldn't even see. She probably couldn't even see. She would have to turn around to be able to see that side door. So she couldn't even have been there long enough to watch John walk up the driveway. That's just factual evidence based on the GPS. That same GPS that shows that John's phone, at least, never went inside the house. And that's just beyond any debate at this point.
Now, there's another article in October of 2024 from Vanity Fair. And here's what this article references. There weren't many cars in the driveway, and Reed felt uneasy. McCabe had conveyed the invitation, so Reed wasn't sure how welcome the couple actually were. O'Keefe said he'd check out the scene and report back, but minutes passed without word. I got angry, Reed tells me now. She knew that a woman O'Keefe used to hook up with lived a few houses down the street. After about 10 minutes of waiting, Reed drove to O'Keefe's house. So what's the story on how long she waited? Is it like 10 minutes? And from your perspective, Nick, does the other evidence support that?
Well, we know she hooked up to John's GPS at around 12:36. So, Kevin, I believe you said it was 12:24 around that time when she pulled up. So, I mean, I don't think she's looking at the clock saying, oh, look, I was here for 10 minutes exactly. I think it's a rough estimate of how long she was outside. But we know that Jennifer McCabe puts her outside at around 12:45 because she said she sees the vehicle move up. But that can't be true because she was already connected to the Wi-Fi. So if we want to say, Karen Reed's story is changing, then we also have to look at everyone else's story that's changing, which the Commonwealth being number one. They have 3 different theories on this case. The first one was she threw the cocktail glass at him and it was a domestic case. Then the second one was she did a 3-point turn and she hit him. And now the third one they're sticking with is she drove 62 feet forwards and backed up 62 feet and hit him that way. So, if we're going to sit here and critique every interview that she's done, which the defense is not afraid or have even opposed any of these interviews being given over to the Commonwealth, if we're going to critique and listen to every word she says, then you better start doing that with the witnesses and even the Commonwealth themselves.
Nick Rocco, Kevin Lenahan, always great to have you on the show. Incredible insight into the facts of this case. Okay. While prosecutors allege Karen Reed's story changed, she never testified in court. She didn't take the stand. And now with the retrial coming up, she'll have another opportunity to tell her story. But I think just like the first time around, we won't hear from her because the defense case is more about what police did than what Karen did. But the question is, will the next jury want to hear her story straight from her mouth? I'm Vinnie Politan. We'll keep digging for answers as the investigation continues.